It's wonderful to see so many people here tonight and to see people representing community groups, trade unions, and of course academics from the University of Wollongong. I really appreciate the opportunity being given to me to give this public lecture. I'd like to thank Dr. Robert Carr for his assistance in organising tonight's lecture, and also to Dr. Glenn Mitchell for sponsoring this public lecture tonight. My talk tonight I've called Waking Fright, because this talk is about how transnational corporations and the executive arm of government have collaborated in a process to restructure our system of governance, to asset strip our public sector, to harvest our resources, and to harvest the incomes of our people. Now, you may think that such a massive undertaking would be well known by all of us, and that there would be much public debate and concern being shown in the media. But no, this is not the case. And the reason is it's not the case is that these changes are being introduced by stealth. No broad policy, no narrow policy, no election promises or policies, no referendums, no public debate, no analysis in the media. Just a quiet, steady process building a new order. It is like a puzzle. And because it's like a puzzle, I'm presenting my talk tonight as numerous puzzle pieces. I'm going to cover 7 pieces of this puzzle, even though there are more. But these are the major pieces that will paint a picture. And the reason why I've taken the puzzle as a metaphor for what's happening is it's because before us is a pile of puzzle pieces, and they actually need to be put together. And once they're put together, it actually paints a picture about how this new order has been created, what the mechanisms are, and what the likely outcomes of it will be for ourselves in the near future and for future generations of Australians. I would like to start with the cornerstone piece of this puzzle, which I have referred to as regulation, and I've called this section of my talk, How Business Got into the Driver's Seat. We've had a regulatory system in Australia that has served our nation well. But this system has been under attack by people using words like liberalisation, harmonisation and innovation. One of the biggest salvos launched at our regulatory system was in 2006, when the Howard Liberal government set up a task force on reducing regulatory burdens on business, because business was claiming that they were over-regulated, that compliance costs were too high, that innovation was stymied, and that our global competitiveness was impaired. Something had to be done. Regulators' behaviour and performance had to change, and people had to stop seeing regulation as a panacea for society's ills. This task force had a lot of input from business, and one of the submissions was received from the Australian Bankers Association, who complained of the Consumer Credit Code. Now, this was just 2 years before the global financial crisis. But I can assure you that the GFC has not dampened businesses' desire for deregulation. They pursue it endlessly. In 2012, the Business Council of Australia published their standards for rulemaking. What interests me in this document is the use of language and the placement of business at the centre of the universe. So, what do they say? The BCA accepts that there is a rightful role for regulation in the economy and believes that effective regulatory institutions are one of the cornerstones of an effective market-based economy. Let me rephrase that from the perspective of a citizen. I accept that regulation has a vital role to play in our society, and I believe that effective regulatory institutions are one of the cornerstones of our democratic society. What we see here with business is a takeover of the language, and this is the first task of the coloniser. So we are really seeing in Australia the colonisation of our society by business thinking. The BCA is framing the meaning of regulation, defining it, and showing that the only legitimate lens is the economic one, and the market-based economic one at that. Referring to the health sector, they state, the ageing of the population means that Australia is confronting a significant social and fiscal shift. The traditionally restrictive regulatory approach in high-demand markets like health and ageing are simply not sustainable if we are to provide the right services at the right time, the right price, in the right quantity. I am sure that many patients and staff in Australia's healthcare system are unaware of just how the current regulatory system is in the way of efficient and profitable business practice. In December 2012, a compact was signed called the National Compact on Regulatory and Competition Reform. It was signed between all levels of government and business, federal, state and local, committed to apply best practice regulatory impact assessment and demonstrate that the benefits of regulation would outweigh the costs to business. And business committed to identifying opportunities for reform, develop options and provide feedback on regulators' performance. So here we have an extraordinary situation where the relationship between regulator and regulated has been completely turned on its head. Rather than business fighting against proposed regulation, regulators must now prove to business that any regulation proposed is cost effective. So, here is our situation. The task force research is done, the standards for rulemaking are written, and the compact is signed. But is deregulation a done deal? Well, let's go check out what the Federal Department of Finance and Deregulation have been up to. Within the Department of Finance and Deregulation, there is an Office of Best Practice Regulation, and their job is to process applications for regulations sent to them by government, departments and agencies. So how do they do this? Well, the OB TPR, as it's called, first assesses whether the proposed regulation needs a regulatory impact statement, an RSI. RIS. So, if so, the department or agency proposing the regulation has to fill out the statement. To help them do this, they can go onto the internet to the business cost calculator. This calculator uses activity-based costing methodology, so public servants can then work out the cost to business and compliance of said proposed regulation. Only the cost of business triggers a regulatory impact statement. The impact on the community, environment, workers, etc. does not constitute a trigger for an RIS. Also, what is framed in language are the groups that are considered to be impacted on. They are business, government, and consumers. So citizens of this country are only seen through this business lens, this economic lens. They are not citizens, they are consumers. Statements are required for international treaties, ministerial decisions, COAG decisions, accreditation schemes, industry government agreements, and even election commitments that involve regulation, which would be more or less most election commitments. So regulation impact statements are pivotal in managing the rulemaking process, so pivotal in fact that recently the BCA, Business Council of Australia, called for them to be mandatory. Why? Because, and I quote from the Department of Finance and Deregulation, no regulatory proposal should go to the Cabinet or any other decision maker unless it has complied with its RIS requirements as advised by the Office of Best Practice Regulation. In other words, this small office within the department is a filter for regulation for this nation on behalf of business only. So not even the Cabinet will even see half the proposals probably get up. So this is an extraordinary impact and change on our system of governance in Australia. So the Office of Best Practice Regulation effectively becomes the gatekeeper for regulation in this country. Now, 2 weeks ago, Tony Shepherd, who's the President of the Business Council of Australia, launched a campaign called When Business Works, Australia Works, and he launched it at the National Press Club in Canberra. And he called for deregulation in that speech, as if no deregulation mechanism had been put in place. So the process that I have just discussed is already in place, that the Business Council of Australia is talking about it as if it's something that they want, that they don't already have, but they actually do have it. And this is very, very deceptive. Tony Shepherd also said that the next 6 months is going to be absolutely critical. Now, we have a federal election in mid-September, but 6 months from now, one of the most critical things that's going to happen in this country is the signing of the Trans-Pacific Partnership Agreement in October this year. Now, I've called this section of my talk the elephant in the room. And as you can see, the elephant has engaged Mr. Obama, but Julia Gillard looks not to wishing to have a look at this elephant at all, and is smiling the other way. Now, the Trans-Pacific Partnership is an investment agreement. It's presented as a free trade agreement, but it's out of 26 chapters in this agreement, only 2 cover trade. Now, none of the documents about restructuring our regulatory system discusses the requirements for change brought about by Australia, signing trade and investment agreements like the TPP or the Australian-US Free Trade Agreement. There are merely hints, such as in the 2006 Task Force on Regulation and Competitiveness. And in their report they say, the relentless forces of globalisation mean that Australia needs to continue to drive reforms aimed at removing any impediments to efficiency and innovation. Underpinning a country's competitive success internationally is the effectiveness of its domestic regulatory structures. So the priority here is to create regulatory structures that favour globalisation, or more specifically, that favour opening our markets to transnational corporations, which is achieved through international agreements like the TPP. Some here will be familiar with the Australia-US Free Trade Agreement, which set the pace in regards to market access to Australia public sector. So who could forget when John Howard gave a special pledge to the US to fully privatise Telstra. The TPP completely dwarfs the 2004 Free Trade Agreement. It is in fact an investment agreement that focuses on breaking down barriers to foreign investment, with far-reaching impact on the national economies of the countries that are a party to it. And those countries are the United States and Canada, Australia and New Zealand, Chile, Mexico, Peru, Malaysia, Brunei, Singapore, Vietnam, and Japan, and possibly Thailand will join this agreement as well. Now, can I have a show of hands to see who in this audience has actually heard of the Trans-Pacific Partnership? Okay, so less than half the audience. Now, this is not surprising because the Trans-Pacific Partnership Agreement is completely shrouded in secrecy. It is being negotiated by the Department of Foreign Affairs and Trade and representatives of 600 corporations representing transnational corporations and those based and located in the countries in the agreement. The Department of Foreign Affairs and Trade has not released any published text of the negotiations, even though at this very moment we are in the 17th round of the negotiations, and that these negotiations started in Melbourne in 2010. This agreement is so secretive that Congressman Ron Wyden, who was chairman of the US Senate and Trade Committee, has been denied access to the text, even though the Senate in the US is constitutionally responsible for trade. So this is quite an extraordinary lockout of parliamentary representatives and other organisations that represent different groups in our society, like trade unions and community groups, etc. So it's very, very much a tight, very secretive negotiating environment. Now, one of the most important aspects about the TPP is a mechanism called Investor-State Dispute Settlement, ISDS. This is a legal mechanism that enables corporations to claim monetary compensation and reversal of restrictions if any domestic laws or regulations impede or have an adverse economic impact on these corporations. Now this can be in the current term, or it can be for future loss of profits. Investor-state dispute settlement is already operational in other agreements. Under NAFTA, the Canadian government has dipped into its revenues big time to defend numerous cases brought against it by corporations. And I'll give you an extraordinary example, which is a company called Lone Pine Resources, which is an oil and gas company based in Delaware in the United States. This corporation is suing the Canadian government in Quebec for $250 million because the government decided not to issue the company with a license to frack for coal seam gas under the St. Lawrence River. And the Canadian government has also had other cases brought against it in the environment area and also in regards to pharmaceuticals. So this is quite extraordinary as well, because with these investor-state dispute settlements, they're not judged in domestic courts. It's a private international tribunal of three. They are arbiters, three arbiters, and they make the decisions. Now, taxpayers' money is going to be spent on fighting cases, and where cases are lost, there is compensation to be paid, and the loss of whatever the government was protecting, whether that be quality, occupational health and safety, public health, cheaper medicines, fisheries protection, etc. There is also a far-reaching effect of this particular mechanism, which is what they call regulatory chill. This term is used to describe the reluctance of government to regulate because of the legal costs and also because of the bad press against the government when they engage in spending taxpayers' money in defending their regulatory processes and any new regulation that they want to bring in. So it's really quite affecting on the whole process of creating regulation and how that process is governed within a particular society. And I think that it's a very, very critical situation that's going to have far-reaching impacts. Now, the political situation in Australia is quite interesting in regards to ISDS because the Howard government did not want it included in the Australia-US Free Trade Agreement in 2004. The Gillard government has come out and said that they don't want it. And my questioning of the Liberal Party in recent times to find out what their policy is, they weren't for it, but they weren't against it. It was rather difficult to determine what their position was, but can I say there was not much enthusiasm for it. However, there is enthusiasm for these legal mechanism from Australian business. The Australian Chamber of Commerce and Industry wants ISDS clauses put into the Trans-Pacific Partnership Agreement. And this is of grave concern because they put a lot of pressure on the government. Now, the TPP is set to impact trade in services such as banking, asset management, superannuation, etc. And this will have an effect because of the deregulation in the financial sector, which is occurring in order to prepare for increased capital flows under the TPP. Now, I would like to also conclude this particular puzzle piece with a statement from Professor Jane Kelsey, a New Zealand law academic, who said, "This is really a charter of rights for foreign investors." And I think that she certainly gives a very, very succinct and clear statement about the true nature of the Trans-Pacific Partnership. The TPP, because it aims to free up capital flows between signatory countries, the Department of Foreign Affairs, in one of their reports, stated, inclusion of investment and financial services chapters in the TPP could provide improved opportunities for Australian financial services providers by mitigating barriers. And this is exactly the process that has been undertaken in Australia today, the removal of barriers to foreign investment. Now, currently foreign ownership of Australia's assets is controlled by the Foreign Investment Review Board, and they have a mechanism called Foreign Investment Screening Threshold. Now, this threshold, which is over all purchases of land and takeover of companies, has to be notified to the review board, and under the free trade agreement with the United States, the amount of money that they can invest without the board reviewing those purchases is 1.1 billion, and also under the closer economic relations with New Zealand, that's also 1.1 billion. So that just indicates just how these trade agreements actually have an impact on our domestic processes. The threshold for every other country is $248 million. Now, the Business Council of Australia wants that to become $1.1 billion for all countries. So all countries around the world can invest that amount of money in Australia without the Foreign Investment Review Board being notified. And of course, the Trans-Pacific Partnership is in support of this because an investment threshold constitutes a barrier. So, what's wrong with raising foreign investment thresholds? Well, there is two major issues that I would like to cover in tonight's lecture. Firstly, the acceleration of selling off the farm. I'm sure many of you here are familiar with that expression because it's been a long-held issue in this country and came out particularly in the Whitlam period, when under Rex Connors there was an attempt to buy back much of Australia's resources from foreign investors, particularly mining. The other concern about foreign investment in Australia is the privatisation of public assets. Now, the reason that this is a problem is that there are investors worldwide who are looking for huge untapped profits, and the public sector represents those untapped profits, because if you transfer health, for example, and ageing services out of the public sector, which is mainly financed by government through taxation, and into the private sector, then this money that's looking for an investment can invest in those sectors, and that's where very, very large sums of money can be made. So these huge returns can be generated by turning public hospitals and TAFEs and assets like ports into private assets.